Assalamu alaikum, and thank you, Justice Hassan. Ladies and gentlemen, can I just first say what a privilege it is to be here, and I have enjoyed the Pakistani hospitality immensely. I shall go back with fond memories of this event. I have been asked to speak for no longer than 10 minutes, which always reminds me of a panel where the chair was an American attorney and one of the panelists was a rather self-important and pompous professor of law. And of course, as you know, on these panels, unfortunately, people encroach on each other's time. By the time it got to the professor, the chairman turned to him and said, "Professor, please keep what you have to say to just 6 minutes." The professor puffed up his chest and said, "How can I possibly share all my knowledge with you in just 6 minutes?" The chair said, "Professor, speak slowly, speak slowly." Thank you. Ladies and gentlemen, I've been asked to talk about the Chartered Institute's Business Arbitration Scheme. The reason for that is that the new Pakistani chapter, a branch, will be establishing a similar scheme to that which we run in London. Let me first give you a little bit of context. In the UK and globally, there are many different types of arbitration schemes. There are many which are administered by institutions such as the ICC, the LCIA, and CIArb in Singapore. You then have ad hoc arbitration schemes which have their own sorts of rules. These are schemes such as the London Maritime Arbitration Association, the Singapore Rubber Exchange, and of course the Chartered Institute's own business arbitration scheme. The disadvantage of the big institutional schemes that are administered out of Paris, London or Singapore is that they are extremely expensive. The ad hoc schemes are usually based on their own sets of rules, tailored to the use of their users themselves, and they have a significant advantage that they are economic. They usually are in particular sectors, commodities, maritime, construction, or banking. But the key to success of these ad hoc schemes, which are based on their own tailored rules, is that firstly, they are economic, but their success also relies on the appointment of the right arbitrator for the case before that arbitrator. So, for example, in the maritime world, before the London Maritime Arbitration Association, the appointment of arbitrators comes from a pool of arbitrators who are well experienced in the maritime world. And similarly, in construction type arbitrations around the world, the people who are appointed as arbitrators are well versed in the construction industry. But the one thing that is critical to that is common to all these schemes is that the arbitrators must be appropriately qualified, and it is one of the jobs of the CIArb to provide that sort of qualification. And the second point is that the pool of arbitrators must be diverse. It must come from a pool which is broad in gender and age as well as experience. It should not be a sort of old boys club. So let me turn to the business arbitration scheme that we run in London and which we hope will be implemented here in Pakistan. The first thing I'd like to say about this particular scheme that we run in London is that it's primarily aimed for small to medium-sized claims which range from about 5,000 English pounds to 100,000 English pounds. The fee is fixed, so the users know exactly how much they will have to spend, and the fee is fixed at a very economic rate. The speed with which the process is undertaken is to be commended. 90 days from the time of filing the arbitration to the rendering of the award. and pleadings and witness statements are limited to just 5,000 words. The appointment of the arbitrator is made by, in some cases, the president or sometimes the chair, such as myself, of the institute. So, for example, last night I received an email from London in a very complex construction case that was less than £100,000, and I was provided with 5 names of arbitrators and their CVs, and it was my job to go through those and score 1 to 5 which of those arbitrators would be most suitable to dealing with the case in hand. And so I reviewed their CVs. We have 5 different arbitrators in case the first one finds that he or she is conflicted, and we can go through the numbers till the right arbitrator is found. But we have the details of their CVs and their background on the database in London, so we can ensure that the right qualified arbitrator is appointed for the job in hand. So what I hope we can emulate here in Pakistan through the Chartered Institute's chapter here is a similar scheme which is economic and expeditious and will provide a good way of alternative dispute resolution for the users of this scheme here in Pakistan. Thank you very much.